안녕하세요. 이 토요일 오후에 이렇게 함께 할 수 있게 되어 참 귀한 시간 감사합니다. Hello, it's nice to see you on this Saturday afternoon. Many people would like to take their rest, but you are passionate to listen or to build up your knowledge about international adoption from Korea. Thank you for your coming here, and also for the people who are sitting in front of our YouTube channel and listening. People probably in the States or Australia or in Europe. Thank you very much for your attendance, even though we cannot see you. Thank you. Probably I have to say this session is the third session. Last June, we have had this first session about this dialogue with adoptees, law and policy. It was grateful. It is a great session that time. And second session we have had in July, a 2 days workshop. It was also very impressive. We have had a good time to build up our knowledge about international adoption from Korea, or in relation with internationally with other countries. Probably I have to introduce our speaker first. Dr. Kyung-eun, last time also I introduced you. She is the one and the only expert in the field of Korean adoption, especially in relation with the law and also international human rights. And she served as a governmental officer. She was once at the Blue House as a deputy secretary for the overseas communications, and then she moved her position into the health and social welfare ministry. And she was working as a director of this ministry of the division of child welfare. And that time she was very supportive, or even she led the revision of special adoption law. And then she studied at the Seoul National University for her doctoral course and thesis. And she wrote the thesis, and that thesis is a huge impact for us to understand what kind of legal background has been practiced in Korean adoption with the international field. After she was served as a governmental officer, she started to work as a research professor of Korea University Human Rights Center, and also she was working or leading the Amnesty International Korea 2 years. Probably you can see her career here. Probably it could be helpful to her background, and also understanding our supportive to understand our lecture. And then today's program is 1:30 lecture 1 and break, and lecture 2. One is 67 years legacy of orphan adoption law, policy and practice. And second one, case study on adoption of Korean orphan between US and South Korea. I hope you enjoy today's session, and hope also the people who are sitting in front of YouTube channel. Thank you very much for your attendance. 감사합니다.
Hello, I'm Kyung-eun Lee, and some of you have been with me already last June and July. Thank you for coming back, and some of you who joined the first time today and who are with us through the YouTube channel, I'm very happy to meet you. And yes, I want to express my deep gratitude for Pastor Kim and staffs of KoRoot, because it is without them, this lecture and opportunity cannot be possible. And I started a dialogues with Adoptees program, collaborating with KoRoot, because it is the most reliable adoptees rights NGO in South Korea that I can work with. So thank you very much. And kindly, Pastor Kim introduced me as speaker, Kyung-eun Lee, and for those of you who are not really know who I am, I would introduce myself. Basically, I'm a scholar of on international human rights law, and had experience working in international human rights NGO and Korean government. And the reason that I started this dialogue is that my dissertation topic for PhD in law is international legal protection of the rights of the child in intercountry adoption. And okay, so I'm going to start this lecture reading together the title. It's South Korea's legacy of 67, it's almost 70 years of orphan adoption and the violation of adoptees' rights to know their origin. I indicated those letters in different color because I want to show that they are related by causality. The red part is the cause, and the green part is the effect. So they are connected, which means that if you find individually and personally find obstacles to know the true birth record and the information of your origin, it is basically, this is the reason. That hardship comes from the red part. So, if we cannot make changes here, I think that this difficulty, this hardship, we cannot make changes here either. So they are connected. Since I'm a legal scholar and trained to see an issue from the perspective of legal structure, I think that adoptees birth family search is a systematic issue rather than individual one. I try to approach and frame intercountry adoption of South Korea by the problem of its law, policy, and practice maintained for almost 70 decades since the Korean War. And looking at details about this problem will be the contents of today's program. And also I want to talk more about this title, Dialogues with Adoptees. And some of you may wonder why it's dialogue. It's just a one-way lecture. Why this dialogue? Yes, the format of this program may seems like, not really, not like a linear dialogue actually. But when I say dialogue means it's not like a dialogue between you and me. Rather, this is the dialogue between adoptees and Korean society. Here's the story that I heard when I was working in Korean government. It was late 1990s or early 2000 when first adoptee reunion was held in Seoul. It was the President Kim Dae-jung era, and hundreds of adoptees gathered in the center of Seoul and held a big union, big event. And there, an official of the Ministry of Health and Welfare came to the reunion and met with adoptees, and he said, "We sent you out wishing that you live well there, and why are you coming back?" His question was, why are you coming back? Maybe he was really curious, or we may analyze or interpret this remark in many ways, but I want to point out this fact. Koreans never expected nor imagined that adoptees would come back to this country again. Therefore, the Korean society is not ready for this. Korean people does not know what to do to receive and meet with adoptees appropriately. Language programs, motherland tours, and cultural experiences such as wearing hanbok or making kimchi are available. And F4 visa, we have F4 visa, so that adoptees can live in Korea long term, and it is possible to restore Korean nationality. However, always the most difficult thing remain to the last, which is access to the true identity, information of birth family, and circumstances surrounding the adoption. These are factors that constitute the origin of a human being. Knowing and preserving one's identity is a human right entitled in the UN conventions. But Korea is not prepared for such questions and needs of adoptees. Whose obligation to solve this situation? Of course, the state party, the government, but in reality, it seems that this government does not realize this obligation. Because the adoption procedure has been so privatized in this country, access to identity is also personalized and individualized. The rhetoric of adoptees birth searching does not escape from individual realm to bringing out the collective, social, legal, and public area. Right holders' voices are most important. Yes, this is the book that I wrote with Jeon Hong-kie, reporter, and Jane Jong-trenka, an adoptee writer. And with all three of us, we wrote together, and it was published in 2019. And the title is 아이들 파는 나라, literally translated, baby selling country. And the subtitle is a report of the intercountry adoption of South Korea. And the first phrase of this book is, we are disclosing the state as the principal offender in intercountry adoption. And this story was awarded many prizes from Media Watch NGO, Amnesty International, National Human Rights Commission, and even the Presidential Medal. But we could not win at the idea of war. I mean, war of ideas. We cannot win in. Korean society feels so uncomfortable to this issue, and I think it would be really difficult to make them understand that to know one's origin is human rights. This is why I think that dialogue between adoptees and Korean society should start now. We have things to understand together. And I'm not representing the Korean society, but I just want to help to open the door or give you some vaccine so that you are not frustrated too soon or too much. Okay, this was the introductory part of my lecture, and this is the graph representing the official records of number of inter-country adoption from South Korea from 1953 to 1953 to 2019. South Korea is one of the few, if not only, countries in the world to keep records of the numbers of children it sent out every year from the beginning, and it published every year. As of 2019, I'm sorry. I'm sorry, maybe. Yeah, we need to change. I think we need to change the file. But yes, and the official number from the whole graph, when you add up that's 67 years, the number reached, where is it? Yes, 167,864. Yeah, that's the total number, and it is amazing that they collected that number every year, and they pronounced and they published it officially. But considering the cases reported nationwide, independent adoptions from orphanages or outside the control of adoption agencies, it is national. Okay, let's see. Yes. This is the official number when you add up all those numbers. It is national to estimate that the real number would be more than 200,000. That's why we are saying that Korea sent out 200,000 children to overseas. And especially if you see this, this is from 1970s, and especially for during that 2 decades, 1960s and 70s. If you add up all those numbers of children sent out, it reached 110,000. 110,000. So this is the area and the period. And in other words, this is the generation, the biggest, generation of adoptees from South Korea. And this is the World Inter-Country Adoption Graph published from Hague Conference on Private International Law. And this red line is the world, the record of numbers of the world inter-country adoption, and this is Korea. And you can see that by 1980s, half of the total inter-country adoption in the world experienced by the children sent out from South Korea. And you may wonder then what happened here. It's China. Okay, let's see this red line again. The red line, if you see this line, I already told you that this is the record collected by Korean government. But in worldwide, these numbers, the number of children for sent out for intercountry adoption from their country where they were born, the number is collected from the immigration authorities of receiving countries. Most sending countries do not have such an effective administrative system to collect those numbers. So receiving countries' authority are the reliable sources for these statistics. And those two countries, South Korea and China, these two countries explain the shape of the world graph of intercountry adoption. And often China is mistaken to have sent more children abroad than South Korea. But this is due to misinformation regarding the span of statistics. You know, the Korea's, in case of South Korea, it goes, long this way. And when everything is considered, it is estimated that China had 152,000 cases. So considering the population ratio of these two countries, you can understand that the singularity of South Korea has in the history of world intercountry adoption. This is the topics that we discussed in the previous lecture. I talked about the traditions of Korean family laws. Yeah, we talked a lot of family laws and how the adoption system was privatized, and what's the effect of this traditional family laws of Korea. And those were the reasons we took the examples and the reasons that child protection, they could not provide proper means of child protection, and orphan adoption system was distorted and manipulated to satisfy the purposes of the political regimes. And this time, we are more going to talk about the obligation of the states. Domestic adoption can be a matter of child protection and family relations. But intercountry adoption should go further. It is the relations between the adopted persons and the country they were born in and the country they were adopted. And it is also the relations between the state of origin and the receiving countries. So it is more official, public, and international matter governed by the laws on the immigration and nationality of both countries, state of origin and receiving countries. This is the process. It's that intercountry adoption involved. It's very long and winding. To finish all those procedures, it took years. It's a long and winding procedure from family law of state of origin and the immigration system and cross-border and immigration system of receiving countries and adoption laws or family laws of receiving countries and the citizenship or nationality procedure in the receiving countries. For a adoption cross the border of a child, should go through all these procedures without exception. So your search, if you are adoptee, your search for your identity and origin is not really personal or individual, because all those adoption, more than 200,000, all those adoption should have gone through this procedure without exception, because that's the law that governed. So, if a state of origin, they may have some distortion or lack of legislation in regards to intercountry adoption, but those receiving countries, those countries are very, considered as well equipped with, and they are very strict in, especially immigration system. So it is really, hard and strictly regulated procedure you can imagine. And actually, this slide is, the example of this slide is from South Korea to the United States. And you can see why, this adoption decree and citizenship is divided, especially divided, because United States has federal system, so the jurisdiction in regards to adoption decree and the jurisdiction about citizenship is strictly divided. So that's why, we are witnessing these days the deportation of adoptees, the phenomenon of deportation adoptees. That's because this process is not really connected in case of United States. But I think basically this slide, this illustration may be able to be applied to other receiving countries in Europe. And we are going to see what happened, because I said that this is the relationship between the country and the adopted person was born, and between the person and he or she was born and the country. So the basic relations between a people and a country is nationality. When I see a question of participants here, there is a question about how Koreans get nationality, because all the adoptees had Korean nationality once when they were born, and in international norm, when we see the countries, usually we can divide the system of nationality in many countries in two types. In one type, nationality goes by blood. We call it jus sanguine. Nationality goes by blood. If you are born to Korean, then you have Korean nationality. And in some countries, the most well-known example is the United States. Nationality goes where you were born. And we call it jus soli. So if you are born in the territory of the United States, then you get the citizenship of the country. So because you are born in South Korea to Korean parents, to a Korean, every adoptee had Korean nationality once, but registered as an orphan erased all the birth family relations, and the nationality was useful for application for passport of South Korea and visa of the United States. And the passport was used only once, one way to leave the country. And Korean Nationality Act, governed by Ministry of Justice, had this article, this provision since 1948, and it regulates all the national who falls under one of the following subparagraph shall lose nationality. And one of the cases is that a person who has been adopted by an alien, foreigner, and has acquired the parent's nationality, then automatically the nationality is cancelled. According to international human rights norms, dual nationality of a child is natural. Just imagine, you are Korean, born to a Korean parents, but you were born in the territory of the United States. Then for that child, dual nationality of Korean and the United States is so natural. And in this case, a baby was born with Korean nationality, adopted in other countries, and had acquired that adoptive parent's nationality. So it becomes dual nationality. According to international norm, the state should wait, in this case, should wait until the child reaches the age and be able to make his or her own decision which nationality to choose. But this is Korean law. Once it is identified that you achieve other country's nationality, then automatically Korean nationality is cancelled by the unilateral action of Ministry of the Justice. This is the picture of 관보. 관보 means official newspaper. So this is 관보 is official gazette of Korean government. Official gazette of Korean government, and every notification or measures of the government, for example, the proclamation of the law revision and such things, should be published on this gazette to have an official effect. If it is not published here, it does not have public effect. And this is the gazette published on December 1st, 1954, and this is Ministry of Justice's public notification number 1. Ministry of Justice's public notification number 1 was this person lost Korean nationality because of the acquisition of the US citizenship, being adopted by an American. Yes, that's how things were done in Korea. And this is another official gazette in 2000. Yeah, it's 50 years, more than 50 years later. 2000. The appearance changed a lot, but there is another Minister of Justice's public notification, and the number is 2479. Maybe it means that this is 479th notification this year. And the people in the following list lost the Korean nationality by the provision Nationality Act. And you can see the long list of names. This is names, and this is date of birth, and this is sex, male or female, and this is the address, registered at birth, and this is the nationality that these people has achieved, and everybody is indicated as the United States. And this is the cause of loss of nationality, adoption. And this is the date of loss of nationality. And this is the name of Hoju. Hoju means master of the family. And usually the master of a family's name is father or grandfather. But in this case, as you can see, that the name of the children and the name of Hoju is identical. They are same, which means they were registered as orphan. And this address is also all the same, all these people. This is the address of adoption agency. Same list, official gazette, 2017. And the appearance have changed, but basically the contents were the same. They are still doing this. They're still, in 2020, if a child is adopted to a foreign country and acquired that nationality, and automatically, Ministry of Justice will cancel the Korean nationality. Now you may assume, you may understand that if you are adoptee, born in South Korea and adopted to a foreign country, and if you acquired that receiving country's nationality safely, then you must have your name on this Korean official gazette. And what happened? Your name is not here. What happened if your name is not here? It must be very risky and dangerous situation. These two people are all from adopted deportees from United States, and this person is his dad in 2017, and his name is Philip Clay. And these two stories are reported in Korean and foreign media a lot, and so I just used these pictures. Philip Clay, Korean name Kim Sang-pil, was adopted to the United States. Yep, he's him. And where he lived for 29 years before being deported to Korea in 2011. In 2017, at the age of 42, he committed suicide. And Adam Klapser, Korean name Shin Sung-hyuk, adopted when he was 6 and deported to Korea 37 years later. And in 2019, he initiated a compensation lawsuit against the Korean government and his adoption agency for illegal activities and damages done to him, including the use of unlawful orphan papers and ignoring basic obligation to ensure his adoption finalization and his naturalization in the United States. Okay, let's go back to this. So, in those cases of adopted deportee from the United States, maybe these two measures or steps were not taken when they were adopted to the United States, or they may have finalization their adoption, but did not go through this citizenship acquisition. But let's think about what's the meaning of the nationality? What's the meaning of the nationality? In the past, nationality was considered as the rights of the country. And based on this nationality, because the country is protecting the individual, by reverse, the country wants to collect a tax or recruit soldiers. And that was the demand to its nationals. But in 20th century, in modern world, under the human rights regime, nationality is considered as the obligation of a nation, obligation of a country to protect the human rights of its people. So the country should protect its nationals' life, safety, and human rights. But in the inter-country adoption procedure, South Korea, as the state of origin, has been functioning so effectively in canceling the nationality of adoptees, but no government body or public organization was responsible to monitor the naturalization process or the acquisition of the nationality in receiving countries. They just got report. But they never tried to monitor it actively. So when, the South Korea witnessing the phenomenon of adoptee deportees, they try to find out, so how serious is the problem? They want to know it. How serious is the problem? How many people are living in the United States without citizenship? They want to know that. But actually, no agency in South Korea or in the United States cannot give any answers. So they started to find a way, try to find it out, what the circumstances is. And the report is submitted to the National Assembly by Ministry of Health and Welfare. It's produced by adoption agencies. They were checking the acquisition. So they were checking all those adoption files if that citizenship certificate has arrived after the adoption. They checked all those files. And this is the number that we have found out. Among 111,148 cases. This is the official number as of 2016. Adoption to the United States. And this is the number that have verified the acquisition of the citizenship. And this is the number they are still checking. So this is the number that we really don't know in the United States, that they have acquired US citizenship or not. You may well understand how dangerous is the situation to live in the United States without proper legal status. This number is really huge. It's 10%. If we estimate the entire adoption, 200,000, this number is 10%. And actually, this risky situation is very systematic phenomenon. It's not just a single accident. It is kind of very unavoidable consequences of the process of orphan adoption from South Korea to the United States because of the visa type. Its visa type is IR4. And IR4 visa means it is also known as orphan adoption visa. Okay, let's go back to this picture. This means that IR3 and IR4 visa type is different depending on where the adoption finalization had happened, is going to be happen. If the adoption finalization happens here, it's IR3 visa process. If adoption process finalization happens here, it's IR4 visa process. You may ask, well, what's the difference? Just to think about the receiving country's perspective. If the receiving country is going to provide its nationality, its citizenship to an adoptee, to a foreign child, what's the reason? It's because of the relationship, familiar relationship with its own citizen, who are the adoptive parents. So if the family relations is not established, if not adoption finalization, without adoption finalization, there is no citizenship, there's no nationality. You cannot provide your nationality to a foreign national. That's nonsense. So it's because, the family relations was established between, in case South Korean child and American parents. That's the reason, that's the legal background, the foundation that United States can provide citizenship to this foreign child. If adoption finalization happens here, if you cross the border, and the US citizenship can be automatically provided to the child. That's the Child Citizenship Act, which was legislated in 2000 in the United States. But if a child is adopted through IR4 visa, that automatic citizenship process cannot be applied because they still need to finalize their adoption, establish the family relationship with the adoptive parents here. So this is, we have another, table here. This is all those number is South Korean children adopted to the United States. And this is IR3 visa process, and this is IR4 visa process. And as you can see, until 2012, you can assume that all those children adopted from South Korea to the United States, adoption went through by this IR4 visa process. So you can imagine, how risky and dangerous the procedure, the system itself. And all those discussions about nationality and immigration and visa type lead us to this issue, abandonment. But I would say that abandonment, you know better than me that all adoption stories, intercountry adoption stories from South Korea has basically had same story. They are all based on abandonment. But I would say, I want to ask, are they really abandoned, all of them? I think it's kind of myth. they may need myth, for all those systems, IR for visa process, and those nationality things, they are all connected to this abandonment myth. And it was a picture of a newspaper. You may remember or not, many of you have memory of this 2012 Paris gathering of Korean adoptees. They had a big gathering in Paris 2012, and the Le Monde, the prestigious French newspaper, reported these special features about the adoptees gathered in Paris. And you can read, if you can read in French, you can read French. It's Devenus adultes, les adoptés prennent la parole. I want the translation is fine, but anyway, I think that the meaning of this is being adults, the adoptees make voices. And if you see the below, le problème, ce n'est pas d'avoir été adopté, mais d'avoir été abandonné, which means the problem. It's not having been adopted, but having been abandoned. And the story goes like this. When adoptees talk about the access to birth family information, people say, usually they say, you are adopted to find parents and grew well in rich country. What's the problem? And they answered, the problem is not having been adopted, but having been abandoned. They are not complaining about being adopted, but the abandonment becomes the lifelong question that cannot be answered elsewhere except the state of origin. So I think I have to. I really cannot believe that all those 200,000 children were abandoned in South Korea. Then it's like, thousands in year, hundreds a month, and scores a day. Children are found on the streets or on the doorstep of adoption agencies. I think that's really unrealistic. So let me ask you these questions. Are they really abandoned? It's a so simple and stereotyped story. But maybe somebody needs this abandonment myth to make the process, orphan adoption process, to get the immigration status of the United States or receiving countries, and ultimately it is connected with the decision of adoptability in receiving country's national court. Inside South Korea, there is no judicial procedure in the adoption of the child, but in receiving countries is a strictly judicial procedure that has to receive the permission of the court. And in the court, adoptability is the most crucial factor. What is adoptability? It's decision that a child is adoptable. Without establishing adoptability of a child, there is no adoption petition. So this is the start point of adoption procedure. Usually in Western countries, this is called voluntary relinquishment. It's a legal term, voluntary relinquishment. and usually it is in forms of the consent of birth parents to adoption. And the legal effect of this consent or voluntary relinquishment is to sever, terminate the parental rights or responsibility with the child established by birth. So, by this decision, a child becomes adoptable. However, voluntary relinquishment does not mean, just as freely as you can or whatever you want. It's very strictly regulated. It's strictly regulated by competent authorities. Consent should be free will for the best interest of the child, which means that when they say free will, that it should be free from any pressure from family or society or any monetary compensations involved. And before giving this consent, they should be provided with special counseling or from experts, and this is called informed consent. So informed consent means that birth parents should be provided with all the possible consequences and legal effects of the relinquishment and the severance of the relations with the child. And the consent should be verified by competent authority, usually by court. And this is very, it's strictly regulated and it's monitored by government bodies and public organizations, and there is a procedures that you have to finish. This is why the countries where voluntary relinquishment is acknowledged by law, ironically, adoptable child seldom occurs. But in Korea, in Korean law, family law does not know voluntary relinquishment. It is impossible to relinquish parental rights voluntarily in Korea. You may ask that you have heard about Korea's Special Adoption Procedure Act has the provision of relinquishment of parental rights by unwed mothers. I have heard about relinquishment in Korea, but I would say that there is no legal effect according to the civil law, the basic Korean family law. It's mere bilateral private contract between mother and the adoption agency. So I think this is a very typical example of distortion of legal system of the state of origin to adjust the loophole of private adoption system in order to respond to the receiving country's adoption law. State of origin, they need to adjust. They need to show to the receiving countries that this is something that you need to make a decision on the adoption of the child. So they made some kind of a distortion. If you see any injustice in the procedure and in the legal system of South Korea, maybe it is in order to respond to that needs of receiving countries. So instead, because in Korea we cannot use voluntary relinquishment procedure, we made abandonment recognition procedure. Yeah, recognized by the government that this child is abandoned. That was the procedure that this country has created in order to meet the standard of the receiving country's adoption procedure. Yes, we talked a lot explaining this chart last time in June. And there's a procedure that adoption agencies take the babies from the from unwed mothers, and head of adoption agencies apply for orphan registration to Seoul City, and Seoul City registered the baby as orphan. It gave a new registration, and this was almost automatic. It was implemented automatically. And babies get the status of orphan of the US immigration law to enter the US, and this orphan status is also established the adoptability in the state courts in the United States. So that's the reason that I said that abandonment is a myth. Nobody really knows the reality. Nobody really knows the truth. Maybe somebody knows, but the official documents, the official, according to official adoption documents, we can never know what is the truth of the adoptee's identity, origin, or the circumstances of adoption. So one of the tragedy that this orphan adoption legacy has created is not just for the adoptees, but also, all the people who are born in this territory, because it distorted the child protection system fundamentally. So this is the table that I find out is, okay, let's see. What's the purpose of the system of abandonment, recognizing abandonment of a child? It should be basically for the child protection. And it should be the state's obligation to prevent abandonment of a child and provide appropriate protection measures to the child abandoned. So that should be very, fundamental of child protection system of a country. But in Korea, what really happened is, this is year, and this table starts 1976, because it's the year that the Supreme Court Administrative Office began to publish the report of judicial statistics. And the number of child abandoned, found abandoned, was included, the number was included in judicial statistics because that's the part of birth registration. Yeah, in Korea, there are 3 ways to report or register a person's birth. It's birth in the wedlock, and birth out of wedlock, and child found abandoned. And if you collect all 3 numbers, you may estimate the total births in this territory. So one of the factors of the birth registration is child found abandoned. And this is intercountry adoption, number of intercountry adoption. And these 2 numbers are collected, managed, and by totally different government bodies. One is Administrative Office of Supreme Court, and one is Ministry of Health and Welfare. And as you see, those numbers are surprisingly similar, almost the same, until 2012. And 2012 is the year that the law changed and the children's adoption procedure introduced court process. Court process is official. You cannot use fake birth registration in the process of court. So the person who are going to be adopted should be registered according to the law. So they need lawful birth paper in order to be adopted. That's the change made this year. So I said that orphan adoption system does not only had effect to the adoptees who were adopted according to that procedure, but it affects everybody who were born in this territory. And the example is the policy about the abandonment of a child should be a rigor procedure to protect the children, but it was abused for such a long time, almost exclusively for producing orphans for intercountry adoption. That's a real tragedy that this system has. Yes, this is the we started by the relations. Yep. Please try to remember. I think I bombarded really a lot of information and fact sheets for in such a short time, but try to remember. I gave you that intercountry adoption is the relations with a person who are born here and between a person and the country that you were born in. And we talked about the nationality, and we talked about the IR for visa process, and we talked about also that IR for visa process needs abandonment myth in order to establish an adoptability and in the national court procedure in receiving countries. So these are all connected. Everything that happens, that I do understand that every adoptee has individual and different and very personalized adoption stories. But behind those personal stories, under those personal stories, in the fundamental, all those adoptions shares this system. No adoption could not escape this law without any exception. All those adoptions were implemented according to this system. And, you know, this underpart, I told you the intercountry adoption procedure is long and winding procedure that takes years, but the only thing that a nation did was this. They don't care about who are going to be adoptive parents. If the adoptive parents were in adoption procedure, the qualification, monitoring, of adoptive parents and post-adoption services, all those. There are so many important things that a public organization should oversee and monitoring, but the public government bodies what they have done is only these things. They gave orphan certificate, and they gave permission to exit. Yeah, you can leave this country. And U.S. Embassy, they gave IR4 visa. The State Department of the United States, they know so well that this is a really dangerous procedure, but they maintained it for 7 decades. And only these are procedures that happened in public sector. And every other procedures, it was up to the private adoption agencies. That's why I'm saying that this is really privatized procedure from the beginning and until now. Until now, I think that the program was not really served even by the new law in 2012. Yeah, that was the message that I want to deliver through this opportunity. The last time we talked a lot about family laws, but this time, really, the family law matters is not divided from the public procedures, such as nationality. And this is the end of the first lecture, and after the break, I'm going to share two cases of adoption that happened in the United States. One is in 1975, and one is in 2012. So we can see the details of those cases, and I hope you can, remember all those factors that I have explained during this first lecture. Any questions so far?
My name is Bunyang. Thank you for your lecture again. It's a little bit besides what you have talked about exactly, but I wonder if you know how long it took to get visa approved in the 60s, in the 70s, in the 80s, and so forth.
I'm not really sure but in the case that we are going to see in the second part of this lecture, it took about 6 months after the orphan. But it is only this one particular case, so we don't really know how long it takes. We can see that orphan certificate or other procedures from Seoul City, it took a really short period of time. But what really matters is the visa process. And when we saw the case, it took 6 months to get the visa.
So that's approximately from intake of the child to the child is able.
From intake of the child, no. From intake of the
or
child,
just
maybe.
When the application process starts.
Yeah, but we really don't know what happened inside the adoption agencies, because they have to show that this child is really orphan. So with the cases that the child first go to some orphanage and then transferred to adoption agencies. So what kind of skills they have used in the past, that's not really well known outside. the answer?
Thank you.
저 도표 관련해서 질문을 좀 드리고 싶은데 1988년에서 89년 사이에 기아 발견과 고개 입양 숫자의 확연한 차이는 그 이유를 알겠는데 2012년과 13년 사이에 그 차이도 88년, 89년 구간이랑 같은 이유로 바라봐야 되는지 지금 봤을 때 이제 박근혜 정부가 13년부터 이겼기 때문에 그것 때문으로 봐야 되는지 좀 알고.
She asked about what's the difference, what's the reason of the difference of the numbers in 1980s, or if you see those two numbers, there are some differences in 1986, 1989, or 1989. There are some differences, and after 2012 there also are some differences. And she asked, how can we explain this phenomenon? First of all, if you see the total, it's almost the same. So I think that until 2012, the differences between the years, it doesn't matter much, because there can be some kind of a time gap between the intake of a child and the actual the adoption, the child and the living of the country of the child. There is can be some gap. And from this year, I think that this is real abandonment. 300. That's the real number of abandoned child. So, and this is the number of children who were adopted overseas from South Korea, but they were or registered not as orphan, but maybe to their mother, or as the birth registration law indicated, they were properly registered lawfully. And this is real abandonment number. So maybe this is the level of abandonment of child in the previous years. We really don't know what is the real number of abandonment in the previous years. So, but as you said that, you asked that whether the regime, the government matters in this number of children sent away. This is the graph, and this is the year that so-called military regime ends. President Noteu was the last president of a military regime, and this is the end. And this sharp drop of the number of children adoptees happened during Noteu administration. This year is 1990, yes, 1990. And so long, it just dragged. For more than 2 decades, for almost 2 decades, the number maintained 2,000. Comparing to this level, you may say that this is low, but 2,000 every year, still hundreds. Still hundreds, like 500, 300, 400 every year. Yes. I hope this answers your question.
감사합니다. For those of us who are adoptees who didn't grow up in Korea, why is the number so high under the, let's say, government that was a dictatorship? Were human rights just in general not non-existent? Or, I mean, why is there such a sharp decline between when there was a military dictatorship or a government dictatorship and none?
Actually, that was the main issue that we dealt with in the previous lecture in June. And this, sharp increase, the military dictatorship regime at the time, the leadership of the regime at the time, they thought that it is kind of very opening and liberation policies toward the world. Because the world wants Korean babies, they just open overseas adoption as much as they want. That was at the time, that was the foreign policy of that regime. And it goes up like this, and so there was really, the process was like, I think it was really mess. Just to think about it. Every year, 8,000, 6,000, 7,000, then it's like, 500 a month. 500 a month by a limited number of adoption agencies, 3, 4. The adoption agencies was not, it was a strictly, adoption agencies need authorization. So, and the Korean government does not give more authorization to adoption. They keep the number of adoption agency 3 or 4 or 5. So by that limited number of adoption agencies, limited number of workforces, this number handling all those adoptions must be very difficult. And the process was it is really unimaginable what really happened. But anyway, how we can, how this country can drop the number like this so dramatically, it's because of the foreign media. In foreign media, it was the year of 1986 and 1988 is especially important for Koreans because that's the year the first Asian game and first Olympics was held in Seoul. So the the authoritarian regime of South Korea, they really want international reputation as a normal country or respectful country. And they thought that Olympic game is a really good opportunity to show us to the world. However, the response of the foreign media was baby selling country. South Korea produce babies, sell babies, and United States buy them. Kind of news media report was really, there was so abundant news media reports about the phenomenon of intercountry adoption from South Korea. So it was authoritarian regime. So it was kind of easy to drop that number. They only bashing, what they did was bashing adoption agencies and because, we talked a lot about the quota system of South Korean intercountry adoption. Without this permission to exit children cannot leave this country. So that's the regulation, that's the tool, policy tool that the government can use. So it was not so difficult for a government at the time to reduce the number, because they can, they just need to stop to give the permission to exit to adoption agencies. They can control this number, and by controlling the number of this permission, they can easily control the number of the children adopted overseas. Does it make sense? Yes, so that's a really not a long story to tell, but I just try to give essential information to understand. So we are going to stop the first lecture here, and then we are going to have some break, and then we'll gather together again. 언제 올까요? 3:15? 3:10. 3:10 we are going to start again. Thank you.